you are in court because your attorney is late.
Okay, so we only take a record in this court when the judge tells you to? Is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh, stop interrupting me.
Well, we're not on the record.
Stop interrupting me.
Right? I mean, we're not in
Stop
court.
interrupting me.
I mean, that's the reason I don't come to your court at 9, because I know in another court, things can actually occur.
This case takes a different turn from the usual courtroom scenes. Instead of a defendant causing disruption, it is the attorney who repeatedly interrupts and refuses to settle down. Judge Boyd firmly addresses the behavior and makes it clear that the courtroom is not a place for emotional outbursts. Lawyers are expected to uphold professionalism and respect the process even when rulings do not go their way. The judge responds with authority and restores order without hesitation. The exchange highlights the importance of conduct and discipline from all parties in court. This hearing offers a rare look at how judges handle counsel who cross the line.
All right, I'm going to ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done? Because I don't have it in the court file.
I have signed a few of them at this point.
All right, so has there been any new discovery?
Not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket. Okay. There are a couple of cases that are ahead of you, so those cases may end up going before yours. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice on
And
the
say
courts.
that, and it very is typical, because every attorney that's here has a case that's set for jury trial, and this is what ends up happening. What ends up
Happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your Honor,
All right,
I'm
thank
trying to
you.
make a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right. All right. So I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Attorney's remarks begin to drift far from the point even after the judge clearly sets the next hearing time. Instead of accepting the schedule and moving on, he continues speaking and raises concerns that do not help his client. The focus shifts away from preparation and toward unnecessary argument. This behavior risks creating more difficulty for the very person he represents. From the outside, it appears uncontrolled and unproductive rather than strategic. The judge maintains patience, but the tension in the room begins to rise. Professional advocacy requires restraint and clarity, especially when the court has already ruled. As the exchange continues, it becomes clear that the court will soon step in more firmly to restore order.
I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m., and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what? I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm gonna be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is gonna stay there. So I stopped doing that because I need a lunch break, and that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bexar County,
For almost
that
20
there
years.
are
This attorney has practiced in the county for nearly 2 decades, which makes the behavior even more surprising. The presentation comes across as unprofessional and poorly considered rather than strategic. Accusing Judge Boyd of using a court stream for personal gain crosses a serious line and lacks any factual basis. Courtroom broadcasts are commonly used for record-keeping, transparency, or public access. Suggesting improper motives distracts from the case and undermines credibility. Judge Boyd continues managing a federal courtroom with authority and restraint while the attorney presses unfounded claims. The contrast between the judge's composure and the lawyer's conduct becomes increasingly clear. At this point, the behavior appears either intentionally provocative or deeply misguided, and neither approach serves the client well.
of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are
I'm
older than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's
Record.
what happens. So then what
Well,
ends
so
up
being, hey,
happening,
there should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. and then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here,
court starts at 9.
and you need to
I have
be
other
here,
cases,
and you
right?
need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I
Sir,
mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually
reset.
occur.
sir,
And their courts have exactly the same
Sir.
jurisdiction.
right this way, sir.
Proceedings are ready to move on to the next case, but this attorney continues to linger instead of stepping aside. Even after the judge signals a transition, he remains at the podium and delays the flow of the courtroom. This unnecessary pause draws attention away from the matters scheduled to be heard next. Judges rely on efficiency and cooperation to keep the docket moving. When that cooperation is missing, the court must step in to restore order. The moment highlights how failure to disengage can disrupt proceedings even after a ruling has been made.
Hi. All right, Mr. Guzman.
Yes.
All right, so before the interpreter came, and correct me if I'm wrong, your attorneys came forward to let me know that they just received a new indictment. Is that correct?
Yes, Your Honor.
All right, and so that indictment, excuse me. Step away.
I was doing what the court ordered me to do, checking on the discovery.
All right, so what ended up happening is your attorneys. All right. One things have really changed the way people treat people, which I find very odd.
Honestly, I'm completely backing Judge Boyd here because the attorney created this mess himself. He was supposed to be in court at 9 a.m., showed up late on his own schedule, then acted offended when the judge didn't reward that behavior. Courts function on tight timelines, not personal convenience, and when a judge says she's handling dozens of cases in a single day, punctuality isn't optional. Lawyers are expected to act like professionals, not stroll in late and demand special treatment. Watching him unravel the moment he faced consequences was telling, and the reaction came off as immature and unfit for a courtroom setting. If someone can't manage their emotions when a schedule isn't rearranged for them, it seriously raises questions about their readiness to represent others. From where I'm standing, the judge handled it correctly, but I'm curious what you all think about how this played out.